This court held an amendment without leave of court. This court held that an amendment without leave of court or consent is generally a nullity, and that's Troso versus Florida. I guess it's Insurance Guarantee Association, but anyway, it's 538 SO 2D 103, 105, and that was the Florida 4th DCA. And by the way, the law requires that DOR attorneys, child support hearing officers, and the judges of 13, despite what they may think, to follow all statutory provisions and well-established laws regarding service of process. And that's, I don't want to butcher the name, it's Shelkis versus Sutton Hill Associates. And that spelling is SCHUPAK versus Sutton Hill Associates. And that's 710 SO2D 707, 708. And it's clear, strict compliance with statutory provisions governing service of process is required in order to obtain jurisdiction over a party. It's clear that that didn't happen. Well-established law determined that an order entered without subject matter jurisdiction is void. You definitely didn't have subject matter jurisdiction because you never pled, or at least in the record, there's no evidence that jurisdiction was ever pled, despite what Ms. McCarthy just said. But I'm going to hold her to that. And you can go to Cole versus State, that's 714 SO2D 479, 489-490. That's out of the 2nd DCA in 1998, by the way. And the Florida DCA did hold that an order entered without subject matter jurisdiction, the 2nd DCA did, is void. Now, we can go back to Rule 12.540 as well as 1.5404B. I mean B4. That states.
Well, I was about to ask you: is that the rule that you're citing as the basis for this emergency motion that you filed?
It's the basis for everything, that the underlying order is void, and I can challenge jurisdiction at any time. And the fact that everyone has put in such an effort to disregard the question of jurisdiction, we want to say it's res judicata, and the 2nd DCA never addressed subject matter jurisdiction.
Sir, I made a finding on the merits in that previous order, and then also made a comment about res judicata. But go on.
Yeah, and you're wrong. It wasn't merit. If it was litigated, show me exactly where it was litigated. That's not difficult, and you're supposed to be a hearing officer. You've injected yourself in quite a few of these hearings. If you have a witness, Mr. Denton, which I didn't know you were the attorney, have the witness come forward and produce the document so that I can cross-examine the witness as to the veracity of the document. There's
a previous finding by Judge Ayers regarding res judicata. There's a previous finding on your.
No, she did not. Judge Ayers cited the case that did not apply to this case. She never addressed the 120-day service of process, and if she did, show it to me.
And Judge DePaul made a comment that res judicata appears to apply on the.
Appears. Tell him to prove it. That's Judge Smith. Tell him to prove it.
It's she. Judge DePaul handled the emergency hearing, or
she may have she recited what Miss McCarthy said. I don't even know if they're listening or not. Whether she said it appears.
Next parte order that determined your motion was not an emergency.
No, that's fine. But the bottom line still exists. There's no evidence that you served within 120 days. Just have one of the judges say that the 120-day rule for service of process does not apply to Mr. Doss or people who are similarly situated to Mr. Doss. That question has never been addressed. Tell the judge before they rubber stamp it, because we know that Gregory versus Rice stated that a judge should take he can take your recommendation, but he's not merely to rubber stamp it. He's supposed to go and check the record. So it should be really easy for them to just write the doggone order out. And then I can either mandamus or whatever we have to do. Because now that becomes a fundamental law, an issue of fundamental rights protection. But the 120-day, I need a judge somewhere to say the 120-day rule was strictly complied with. That's the issue.
Okay, anything else, sir?
Well, I've challenged jurisdiction. I just need you all to put it in the record. And by the way, is Mrs. Britt, what's Mrs. Britt here to testify to?
She's here because she's a department representative. Nobody's called her as a witness yet.
Okay, let me go ahead and cite Venetian Salmi Company versus That's PARTHENAIS 554 SO 2D 499. I'm sorry, comma 502 out of the Florida Supreme Court. If a defendant wishing to contest the allegation of the complaint concerning jurisdiction or to raise a contention of minimum context must file affidavits in support of his position. I've done that. The burden is then placed upon the plaintiff, which would be the Department of Revenue, to prove by affidavit the basis upon which jurisdiction may be obtained. Can I call Ms. Britt as a witness?